Hello, I'm Rachel Robinson. I work for Liberty, a UK-based human rights advocacy and campaigning organisation. Liberty's been around for over 80 years now. We work across the spectrum on civil and political rights. We were first formed in response to police brutality, the hunger marches in the 1930s, and since then we've tried in all of our work to act as a watchdog on state action, on arbitrary state action. And in recent decades, we've done that very much with the help of the European Convention on Human Rights and the Human Rights Act, which is the piece of domestic legislation which brings the Convention rights into UK law. Today I'm going to be talking to you a little bit about the Convention and the protections it provides, the UK framework for the protection of rights and freedoms, and perhaps most relevantly at this moment, plans proposed by the UK government to actually reduce, water down rights protection, carve some groups out from the protection of our basic human rights laws. I'm going to finish off by talking a little bit more broadly about the situation of some groups in our society, so the challenges facing migrant groups, for example, in the UK today, and certain British citizens vulnerable to having their citizenship actually removed under existing and new and emerging pieces of legislation. The European Convention on Human Rights was really this continent's answer to the horrors of the Second World War and the atrocities of the Holocaust. European countries came together to set down a set of basic principles which must be adhered to protect basic human dignity. So what we have with the European Convention on Human Rights is this core set of basic civil and political rights. Things like the right to life, freedom from torture, inhuman and degrading treatment, freedom from slavery, free expression, the right to respect for private and family life, a real core set of basic entitlements. Of course, we also have the European Court of Human Rights, which adjudicates on the Convention, and what this means is that individuals in member countries can hold their state to account in the European Court of Human Rights. They have that form of redress. What we've also done here in the United Kingdom is to, in a very positive step back in 1998, is to create a piece of legislation which incorporates many of the Convention rights into domestic UK law. So our Human Rights Act ensures that these protections are available to individuals here in the UK. It means that an individual who believes that their rights have been violated by an arm of the state can go to a domestic court here in the UK. Whilst they might ultimately have to go to Strasbourg, they have the ability to seek redress here first. It ensures that public authorities here in the UK are held to account by the standards set out in the Convention. It also provides for a declaration of incompatibility in cases where a piece of legislation in this country is incompatible with the Convention. So it doesn't provide a strike down power as constitutional documents do in some other countries, but what it does is it sets up a real dialogue between our Parliament, which passes the laws, the domestic courts here in the UK, and of course the Strasbourg Court, the European Court of Human Rights. There's also a very important dialogue between our domestic courts and the Strasbourg Court. The Strasbourg Court is very keen to take account of the reasoning of our courts, and the courts in this country also take account of the reasoning of the Strasbourg Court. Now, since it came into force in the UK in 2000, the Human Rights Act has done a huge amount to protect all kinds of people, including some extremely vulnerable people. The Human Rights Act has been used extensively, including by Liberty and Liberty's clients, to protect or seek redress for victims of serious crimes. So, for example, we represented Patience Asukwo. Patience was forced to work in this country by an employer who took her passport, who abused her. She was effectively a victim of modern day slavery. Now, the police, when patients went to them for help, were unhelpful, didn't investigate her case in the way that they should have done. It was thanks to the Human Rights Act that the police were forced to investigate Patience's case and ultimately to bring charges against Patience's employer. Now, at the time, there wasn't the specific offence around modern slavery under UK law, but thanks to Patience's case and the role of Article 4, the prohibition on slavery set out in the Human Rights Act, ultimately a specific offence of modern slavery was created in UK law. That's one example of just how powerful the Human Rights Act can be in its protections for the very vulnerable. We see the Human Rights Act working in many other contexts also. In recent times we've seen it used to hold the state to account for surveillance powers which are not within lawful bounds. We've seen it used to protect minority groups in cases of discrimination. We've seen it used to challenge overly broad stop and search powers used by police, which were disproportionately used against young Black and Asian men. We've seen it used against powers which really target peaceful protesters. We've seen it used to ensure the right to liberty of individuals with mental health issues who are not being treated in the way that they should be in accordance with their human rights protections. So it's an incredibly valuable piece of legislation which has enhanced human rights protections massively in this country. And the fact that we have this piece of legislation, we at Liberty feel sets a positive, broader example to other countries who perhaps haven't incorporated domestically the Convention rights. The real problem, of course, that we are now facing in the UK is with the current government's plans to repeal the Human Rights Act and replace it with a British Bill of Rights and Responsibilities, which will significantly weaken rights protection. I want to talk in a bit more detail about our government's plans for reform of human rights law in this country. Now, we had a set of proposals which were drawn up by the Conservative Party whilst they were part of a coalition in October last year. Now, these proposals are the latest version of the government's of what is now the government's imagining for a new piece of legislation governing rights and freedoms. Now, it's incredibly concerning. First of all, these proposals involve repealing our Human Rights Act, the piece of legislation which has very effectively held the state to account for around 15 years now. What is proposed is to create a British Bill of Rights and Responsibilities. There are a number of proposals for reform within this bill that were set out in the consultation proposals published last year. The first of these is actually to substantively alter rights protection in terms of the individual rights contained in the European Convention on Human Rights and the Human Rights Act. So, for example, Article 8, this protects the right to private and family life. Now, this has been used and can be used in some circumstances to challenge deportation where someone has very strong family ties in the UK. It's actually exceptionally rare for cases, Article 8 cases, to succeed and actually effectively prevent deportation. It's really only in a very rare case that this happens, and actually legislation has been brought forward to make it harder and harder already for those subject to deportation to challenge this on human rights grounds. But the government wants to actually exclude from the protection of the Human Rights Act foreign nationals challenging deportation on the grounds of their right to some respect for their private and family life. That's one of the substantive rights protections at risk under these proposals. Another, really very shockingly, is the prohibition on torture, inhuman and degrading treatment. Again, the government is worried that this is sometimes used in cases involving deportation to prevent people being, for example, removed to places where they face a real risk of torture, inhuman and degrading treatment. Whilst the consultation paper is quite vague, what we're hearing is talk about whittling away this protection, reshaping it, and actually making it a less effective form of protection, preventing its use where it is really needed. So one aspect is actually to target the individual rights. We're also seeing a number of other approaches to reducing protection. So the government wants to see trivial rights, or what it deems to be trivial rights, excluded from protection, so that a court cannot actually adjudicate on rights protections. What is trivial in this context? Well, we would argue that no human rights violation is trivial. By their definition, they're not trivial matters, they're incredibly significant matters. Sometimes a human rights violation can involve a minor action, or what may seem like a minor action, but the broader context makes it highly significant. Now, this is often the case in terms of claims around discrimination. Liberty was involved in a case of a woman who worked for British Airways who was prevented from wearing a small cross as part of her what she wore to work as an air hostess. Now, being asked to remove a small item of jewellery may not seem like a big issue, but it becomes one when this is a very important symbol of a deeply held religious belief. And these are the kind of cases which we're worried could effectively be excluded if the government sets out those cases and sets out in legislation those kinds of cases which it deems too trivial to actually attract the attention of the court. That's seriously worrying. Another strand in the government's thinking is this idea of responsibility. So it's a British Bill of Rights and Responsibilities, and it's the idea that you don't get your human rights as a result of your humanity, as a result of your basic human dignity. It's the idea that human rights are earned, a sort of citizen's privilege, rather than really a human right in the way that we would understand the protection of basic rights and freedoms. So actually, where we see frequently this reference to responsibilities and duties in bills of rights or constitutional documents, it is in very authoritarian states, very authoritarian administrations throughout history and up to the present day. What the UK law and what the law in most modern democracies does is it sets out in a whole manner of ways the responsibilities placed on the individual. So that can be under the criminal law, under the law of contract, so our responsibilities towards each other, towards the state. Most of law is about that, and what a Bill of Rights should be, and what the Human Rights Act is that rare breed of law which actually provides the individual with some protection against the overmighty state. And this basic principle is really at stake under the government's proposals. Another proposal which really hits at the integrity of the convention system as a whole is a proposal that we in the UK should be able to pick and choose which judgments of the European Court of Human Rights we want to implement in this country. So Parliament would be required to approve the implementation of a judgment. Now, as a matter of our domestic law, we're not required to implement the judgments of the European Court of Human Rights, but in international legal terms, we've signed a treaty. And we've said that we will implement the judgments of the court. Now, it's not only our record on human rights protections which is at risk here. The UK actually has a very small number of cases decided against us in the European Court of Human Rights when compared to other countries such as Russia and Turkey. What message are we sending to these other countries if we start talking about picking and choosing which judgments we want to implement? So another incredibly important consequence of our government's thinking for the broader convention system. So why is our government trying to diminish rights protection in this way? In all likelihood, there are a number of answers to this question. Perhaps most obviously is the fact that no government loves the piece of legislation which is there to hold it to account. It's incredibly inconvenient, of course, for the government when the Human Rights Act allows individuals to seek redress against a government department, against a public authority. It's very inconvenient when a piece of legislation is shown to be incompatible with the convention, and the onus is on government and parliament then to change it. Of course, that is the unique function of a piece of human rights legislation. It gives power to the individual, it allows them to seek redress, but inevitably that makes it unpopular with this government, as indeed it has with previous governments. Now, this isn't the only reason for this particular debate in the UK. We have a broader debate here around our place within Europe. Now that is really a debate about the European Union. This is not something that Liberty concerns itself with. We're not here to defend the EU or talk about the virtues of UK membership of the EU. What we do and what we talk about and what we are concerned about is our membership of the Council of Europe and the European Convention on Human Rights. Now these two things are frequently conflated in the UK, either on purpose or because there's generally a lack of knowledge, a lack of information about the distinction. A particular problem that the government faces is that many individuals in its ranks, many members of the Conservative Party, are very sceptical about the EU in particular. But the government front bench, senior figures in the government, don't want to see the UK withdraw from the European Union. There are very powerful business and lobbying interests putting pressure on government to make sure that the UK stays within the European Union. So how does the government square this circle? It wants to appease its Eurosceptic backbenchers, but it also wants to show business that it is campaigning for the UK to remain within the European Union. Well, one very easy answer for the government is to be Eurosceptic on rights and freedoms, so to attack the Strasbourg Court, to attack the convention system as a way of deflecting attention away from concerns that certain members of its party have about the European Union, of course a completely separate institution. So we at Liberty feel that that's really part of what lies behind these reforms. Another issue, of course, is the issue of unpopular groups. This is no new phenomena here in the UK, and I'm sure in many other European countries. This is the idea that certain groups of individuals who are considered unworthy shouldn't receive the protection of basic human rights legislation. This is the idea that, for example, a foreign national who's committed an offence should be extremely limited in the extent to which they can rely on human rights protection. This is the idea that perhaps prisoners shouldn't be entitled to the protection of basic human rights. Now, of course, and as we discussed earlier, that the very point of a human rights instrument is to ensure that rights attach to people as individuals. The European Convention on Human Rights ensures that human rights protections, except in relation to those few absolute rights, are balanced against broader social interests, so protection of national security, prevention of crime and disorder. That is built into the Convention on Human Rights. But the idea that we actually carve individuals out from protection is deeply concerning. And this phenomena of seeking to kind of carve certain groups out and prevent them from accessing protection is part of a broader phenomena in UK law. So over recent years we've seen some very concerning developments around the treatment of asylum seekers, of other categories of migrants. We've seen the growth and expansion of immigration detention in this country. We're one of the few countries in the European Union that does not place any limits on immigration detention. This all comes together to form part of a broader picture of deeply concerning proposals designed to reduce, to diminish the rights of certain categories of migrants in this country, including extremely vulnerable people. But actually, this isn't just about non-nationals. This also extends to British nationals in some circumstances. And what we've seen in recent years is the phenomena of the creation of a sort of two-tiered system of citizenship or nationality. So we've seen introduced in recent years a number of pieces of legislation which actually allow the state to remove citizenship from individuals who are granted that status. Now we've had for a long time on our statute books legislation, or for at least for a number of years, legislation which allows for citizenship to be revoked after certain actions, but only in cases where there is another nationality available to the individual in question. What we are looking at now in recent pieces of legislation is actually attempts to create a situation where an individual's nationality can be removed, even in circumstances where they don't have already another nationality. So this not only raises serious human rights concerns more broadly, it also raises the spectre of statelessness. That the very much the direction of movement in recent decades has been to reduce the level of statelessness which exists in recognition of the very real lack of protection suffered by those who can't rely on a state authority to offer them protection. But what we've seen here in the UK has been successive moves which will result in an increase in statelessness in the world. So here at Liberty, we are really fighting to ensure that human rights protection remains universal. It's not diluted into some kind of scheme of citizens' privileges. We're fighting to retain the Human Rights Act, and our prospects are good whilst the government remains committed to its proposals. And we are in no way complacent about that. We have the support of the opposition parties here in the UK. We have the support of much of the devolved administrations. So it's a fight that can be won, and it's a fight that we will really try to win. Not just because we understand how important human rights protections, universal human rights protections, are here in the UK, but because we know that what happens here in the UK will have an impact further afield. Have an impact on countries who have far more concerning records on human rights than we do here in the UK, so that the Russias and the Turkeys. It will have an impact on the ability of the convention system to really act as a check on abuses by states of individual rights and freedoms. So we will continue to pursue this and continue to fight for the protection of the Human Rights Act.